Hi, I'm Jonathon Kappy.
And I'm Garrett Horrocks.
Welcome to Holland Estates. You're listening to episode number 568. Today we will be discussing no contest clauses.
How are you, Jonathan?
I'm good. How you doing?
Good, thanks. So we're going to be discussing the case of Mawhinney and Scobie, and we'll put the citation in the description of the podcast. So I'll do a quick rundown of the facts, and then we can go into some detail about no contest clauses. So in this case, the testator died with a number of wills. I believe he drafted 4 wills prior to his death. The last one was drafted in August 2015 and included what we refer to as a no contest clause or an interim clause, which essentially is a clause designed to discourage potential beneficiaries from challenging the validity of the will.
In its simplest form, a no contest clause says you may get a gift under this will, but if you challenge my will, it is as if you predeceased me and you get nothing.
Right. So in this case, one of the beneficiaries, Karen Mawhinney, was considering bringing a will challenge on the basis that the last will was executed under suspicious circumstances. She thought that the testator may have lacked testamentary capacity, so she was considering bringing a will challenge to assess the situation. However, before that, because of the no contest clause, she brought an application to the court to determine whether an application for directions would violate or otherwise potentially trigger the no contest clause.
Right. So she was smart. So she really sought an advance ruling. She said she wanted to know from the court, if I bring this challenge to seek the relief that I'm seeking, am I going to violate the no contest clause in the will? Just let me know before I start, because I want to know what my ramifications are if I go and I lose.
Right.
So she sought the court's direction that if I bring this and I lose, does the no contest clause get triggered and I get nothing?
Right. So she ended up being successful at first instance. By way of a quick summary, the surrogate rules of Alberta provide that an interim clause can't apply to vitiate any rights of a beneficiary under statute. So typically that applies to the rights of a dependent, for example. And in this case, the lower court held that that Ms. Mawhinney had a right to bring an application to challenge the validity of the will or to test the waters for suspicious circumstances, and that would not trigger the interim clause.
So I think it's important to start off by understanding for everyone who's watching what she really wanted in terms of moving forward with her suspicious circumstance allegation. All right. So a will traditionally can get proven in one of two ways. Right? You can prove a will in common form, and you can prove a will in solemn form. Right? The easiest way to go about proving a will is in common form, and that's traditionally done by taking the original will, swearing an affidavit, filing it over the counter, paying the probate fees, and the court stamps your certificate of appointment of estate trustee with the will and sends it back to you and you're running. And that's what happened here. They did it that way to start.
Right.
And the estate trustees got probate. The other way to go about getting probate is called proof in solemn form, and that is a much more onerous test that you have to satisfy at a formal hearing in front of the court to prove that the testator had capacity, that there was due execution, that there was no undue influence, that the circumstances were free of suspicious circumstances, and it is much higher threshold of evidence required and a much more expensive form of adjudication. It goes into much more depth. And generally, in common form, if you show that the will was executed in accordance with the statute, that there will be a presumption that they had capacity, that the testator satisfied all the other requirements. But where you raise suspicious circumstances, you can trigger a requirement that a higher threshold of evidence be required. And that all comes from the distinction between courts of probate and other courts. Because generally in courts we think of them as adversarial. You've got two parties who are arguing over the outcome of a particular dispute, and the court's going to pick one side or the other or somewhere in the middle. The court of probate is different in that the role of a court of probate is to be inquisitorial. It is to decide whether a will is valid. It doesn't just bind the parties, it is a decision in rem. It binds the entire world. If a will is valid, it affects everybody whether or not they are part of this particular proceeding or not. And so the courts also have an elevated role because they have to speak for a testator who's no longer alive to speak to their intentions, and so the court has a much more serious role in making sure that only valid wills get probated. And so in this particular case, there was proof in common form. Because of her suspicious circumstances, she wanted the court to require proof in solemn form. And she wanted to know whether requiring proof in solemn form was considered akin to a will challenge, and did it trigger the no contest clause?
Right. So, as mentioned for Jonathan's helpful commentary there, she was successful at first instance, and obviously the respondents appealed the decision, and ultimately they were successful at appeal. So, at the appellate level, the court essentially looked at the surrogate rules of Alberta, which provide that an interim clause can't displace a party's or a beneficiary's statutory entitlement to a benefit under a will. As I said, that's akin to primarily dependent support legislation. The lower court held that a right to bring a will challenge, a right to seek proof in solemn form, for example, is a right conferred by statute. But ultimately, the appellate court disagreed and said, you're not conferring any right. You have a right to seek the court's direction, but you're not being conferred a right. You're not being denied a right that would be provided to you under statute if or on that application.
And I think that I enjoyed the part of the case where the court dealt with the public policy issues that got raised with respect to this. And what this applicant asked is essentially, listen, court, if you've got this rule to be inquisitorial, to look at the facts of the case, to make sure that invalid wills aren't granted probate, how can you take this no contest clause and say, if there is suspicious circumstances, I shouldn't be looking more into this thing? And I think the court had a couple smart responses and retorts to that position. All right, first of all, from purely a scope perspective, the issue of whether or not no contest clauses are either constitutional or whether or not they're against public policy was not something that was argued at the lower court, and they said that I'm not going to deal with that. The other thing that they said in response to her in particular was that the no contest clause does not prohibit your right to challenge the will. If you bring this challenge and you are successful, the will is not valid, the no contest clause is not valid, in which case an earlier will govern, and you've got what you wanted. But if you bring this challenge and you are unsuccessful, you are going to forfeit any gift. And what the court says is that this clause is designed to discourage litigation, not to prohibit it. And I think that is sort of what they look at. It is not stopping you from challenging. It's just saying that if you challenge and you're wrong, there are consequences.
Right.
And so it's not getting in the way of a court ensuring that proper valid wills are granted probate. It's a matter of saying, listen, you want to bring this, you got to be sure.
Right. It's just a matter of sort of, as the court says, testing the fortitude of a potential challenger to see if they really have the stomach for it, so to speak.
And I think that the last line of the decision is somewhat telling, which goes back to another one of the roles of the court of probate, which was the court must also be concerned about its obligation to give effect to the intentions of the testator who put in the no contest clause for a reason. So enforcing this rule is just as important as everything else in terms of carrying out the intention of the testator.
Right.
So interesting provision. There's a whole lot of law about no contest clause and interim clauses, and we don't have the time to go through it all, but this was one interesting case that dealt with it from Alberta. But I think that concludes our podcast for today. Until next time, we want to thank you for listening. I'm Jonathon Kappy.
And I'm Garrett Horrocks.
Should you have any questions, please email us at webmaster@hollandhall.com or leave us a comment on our blog. Have a great day.
Thanks.